Hey everyone, welcome to another special live discussion on immigration and jobs talk show. I'm your host Rajni Bharara, and we have got a special treat lined up for you because we are diving into not one, but two fascinating cases with our guest, Jonathan Wasden. John represents clients on strategies to overcome immigration denials, including bringing cases to federal court under Administrative Procedures Act. For a majority of his career, John worked as an attorney for various US governmental agencies where he defended immigration regulations and decisions under the APA. His last position in the government was with the Administrative Appeals Office, focusing on employment based legal issues and advising on litigation in these areas. He is now a partner at Wasden Banias, a Washington, D.C. metropolitan area law firm specializing in employment based immigration and Administrative Procedures Act litigation. All right. So, today, first up, we'll be talking about a case where Jonathan and his team scored a big win, a mega win. Okay, so picture this. A group of folks with special work visas called H1B visas were in hot water because their employer were accused of doing something shady stuff. But guess what? Jonathan swooped in like a legal superhero and fought tooth and nail for these people's right. And guess what again? He won. Yup. The court ruled in favor of these H1B visa holders, saying they deserve a fair shake and in the government. And the government can't just yank away their visas without a fair fight. Now, on to our second case, which is still hanging in the balance. It's all about a guy named Sridhar Alawala. He's in a bit of a pickle because his old boss got in some trouble for something sketchy ages ago. And now the government's threatening to take away Sridhar's visa because of it. But hold up. Sridhar didn't do anything wrong. So Jonathan on this case trying to make sure Sridhar doesn't get the short end of the stick. So buckle up, folks. We are in for a roller coaster ride through the twists and turns of the legal world with Jonathan as a guide. So let's get started. And before we move ahead, I would like to read out this important disclaimer that is on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Now, John, welcome to the show once again.
Thank you. It's good to be with you.
Thank you so much. And firstly, congratulations on your recent win in the H1B visa case. And if you can please share some of the messages that you got on social media. We were tracking your account. I mean, we were looking into the accounts and people were really congratulating you and on your big win. So if you can also please show it on the screen for the viewers, we would like to.
Yeah. So a lot of the cases that we're working on right now have a common element, which is the government didn't give the interested party in the case notice and an opportunity to respond prior to issuing what amounts to be a punishment or what the law calls a sanction. So in the Narambalada case out in Seattle in the Western District of Washington, it was one of those issues where the employees had all been selected in the H1B cap lottery, been assigned a cap number, were working, and then the government yanked the rug out from underneath them and said, your employer did something wrong, we're taking away your cap number. And so it's important to recognize that when you get your initial H1B approved, there's two different benefits going on. One is the benefit to the employer, which allows them to hire you and make money off of you. And then the other benefit goes to you, the employee, which is your right to change jobs, your right to extend indefinitely if you have an approved I-140. And so what they do in these cases is they take away the employer's right to employ and also try and strip the innocent employee of their cap number. And so very quickly in that case, in Narambalada, like early on, the government conceded the employees did nothing wrong. They're not the ones that are, alleged to have committed fraud. It's all the employer. And then they said, even if that's the case, the court shouldn't hear this issue, and they should dismiss the case. And our argument has always been that the interested party in the cap number revocation is the employee, and they're the only people that get noticed because it's all on them. It's all the negative impact is all on the employee. And so that was our argument pushing, and there's a couple of other arguments, but that was our lead argument. And so the court says they are good to go forward and press their case in federal court.
Okay, great. Well, before we move into and before we dive into the details of this case more, I would like to actually show our viewers those congratulations messages by people on your big win. If you can please share those screenshots or those images here, please.
Me?
No. I'm asking my my team, not you. I was just talking to my team. I'm really sorry about the confusion.
That's all right.
So, yes, but John, meanwhile my team shares these screenshots of these messages, I would like to know from you, how did the win feel? I mean, how did you feel?
It was nice to know that the clients have hope and they're not doomed forever and losing their H1Bs. It's also nice to know that you're right. So one minor correction to what you were saying earlier. So I'm not in Wasden Banis any longer. I'm just at Wasden Law, but I'm doing the Naramballata case with Jesse Bless, and he's another immigration litigation attorney.
Okay, all right. Thank you so much for clearing that out. And okay, and yeah, as people can see on their screen, see these messages from people, and can we also have more? You are fighting the good fight, and then if we can also. Thank you, Jonathan, for your support. And this is about the Sridhar's case, actually. And if we can also show more, see, too many messages actually for John. Congrats on the great work. Make them pay. And this is awesome, John. Thank you for sharing. What a win. This is incredible. So a whole lot of messages from the people, actually. So, and now, John, coming back to you again. And now I would like to talk more about the case. If you can please, also walk us through how you and your team actually stumbled upon this case in the first place, and what actually made you notice it.
So in the Naramballata case, it was all about the multiple registration issues that were, endemic in the 2022 and 2023 fiscal year lotteries. And I guess the 2024 as well was a hot mess. So what we saw is people getting selected in the lottery, working for the employer. A lot of times they didn't know that they had been entered in by multiple companies. They thought there was just one offer of employment. And the reason for that is manyfold. Sometimes the employers would get the list of employees that they wanted to hire. They would share with some other company, and then they would apply without the employee knowing. They also were using recruiting companies back in India who was selling the same list of employees to multiple different employers. And that really ratcheted up the number of duplicate registrations that were going on. But what we noticed is that when they were revoking all of these H1s, most of the time the employee had already moved on. They'd already transferred their H1B to a new employer. And so the old employer typically does not respond to the notices of intent to revoke, because USCIS has said they're going to criminally prosecute people, and so nobody wants to say anything, and those go unanswered. And the only person that really is impacted is the employee, because they're the one whose cap number is getting stripped. The initial employer has already lost their right to employ, and so they get blindsided by this at their new employer with a new notice of intent to revoke the second visa. And so if you were selected in those years that were tainted by the multiple registration, you should probably be checking your case status page regularly on the visa just to make sure that USCIS hasn't revoked it without telling you. So you're not similarly blindsided. But the employees that came to us, they were obviously they had done nothing wrong. They were frustrated with the system. And so we looked into it. The first thing right off the bat we noticed is that under federal law, the statute, the immigration statute, you cannot strip a cap number away from an employee for fraud unless they're the one that commits fraud. And in these cases, the government was very clear early on. Their initial defense was there's no fraud on the employee's part because we're suing them, challenging fraud findings against the employees as well. So very quickly, they backtracked on that. And so under the statute, the employee didn't commit the fraud, so they really shouldn't have their cap number stripped away for the actions of a third party. The other issue I think that is more interesting from a nerdy lawyer perspective is that the anti-collusion rule that is being used to justify all of these revocations was never published the way the rules are supposed to be published. So USCIS went through this long rulemaking process where they provide notice to the public, they take comments, they analyze comments, and then they publish the final rule. They did that when they recreated the new lottery back in 2019. And they changed the structure of the lottery. So they went through the rulemaking process, and a lot of people commented, very well-known people within immigration commented that if they didn't change the structure, it would lead to massive duplicate registrations and frivolous filings that would cause unused petitions. And so people just wouldn't have enough work for the number of employees that they got selected for. USCIS's response to that was, we're not worried about it. What we'll do to solve that problem is we will just require them to make an attestation that they will file a petition. Now, notice there was no attestation about unfairly, working with another employer, nothing like that. So the first 2 years, the lottery goes off without really much of a hitch. It's not that crazy. And then the numbers started to get crazy. USCIS realized they had screwed up. But instead of going back through the process that they're required to under the law to fix it and create new rules and put the public on notice, they essentially just put it up on their website, and that was the extent of their notice. So we're challenging that because they really did not follow the process. The federal courts are pretty clear. When you create a rule like that, you have to give the public notice in a very particular way, which is publishing it in the Federal Register. That's the only way that people know officially what's happening and what the agency is going to be doing. And they didn't do that. And so I think they have a rulemaking procedural problem. Almost all of the cases I do come under the Administrative Procedure Act, and that's the handbook the government has to follow when they make any type of decision or rule. If in my line of work, if we're arguing about facts, it's going to be a rough case. But when we're arguing about procedure, that's when we're at our best. And pointing out the procedural flaw in the rulemaking, I think, is ultimately going to be what wins the case.
Okay. All right. So, John, I'm definitely, you mentioned USCIS, and definitely I'm going to talk about the government, but a little later. But before I move into that, I actually would again like to ask my team, because I'm sure you are very busy. And also, I don't know if you get enough time to read all those comments that you get on your social media and also from people all over, basically. So if you can please respond to them right now. So if I can ask the control again to please post the screenshots of those messages and those comments, and we would like to get a reply for them from you.
Sure.
Great. So there is, I can't see the name actually. Okay. Okay, so William said something. He said, "You're fighting the good fight, indeed, Jonathan. Keep up the good work." And I encourage others in that situation to reach out to you. What would you like to say to William?
Yeah, so Bill Stock is somebody I've known for a while. He works at a great firm in Philadelphia,
Mhm.
and yeah, he's one of the brighter minds in immigration law. So it's good to hear from him.
Amazing. Let's move to the next comment, please. Okay, this is about actually Sridhar's case, so maybe we can take it later. But if we can please move to yeah. So Charles is here, and Charles also says, "Congrats, great work, make them pay." And what would you like to say to Charles?
And Chuck's another person I've known for a long time. A
Okay.
great guy down in Atlanta. He has a really good firm down in Atlanta. But we've been working against stupid government decisions for a long time. He does some litigation into addition to his petition practice. And so a lot of these issues that we're fighting, will bounce off of people like Chuck.
Mhm. Okay. And Roman also says that this is awesome news, Jonathan. Thank you for sharing. What a win. So, and then I would like to read the next comment also. He says, "This is incredible, Jonathan. Way to go." And so, if you can, basically everyone is congratulating you on your big win. And you're going to get these a lot more because you have also had a recent win where you posted, I think, a couple of hours back. So, you're again going to get a lot of messages. So, if totally, if we can get a message for all those people from your side.
Yeah, I mean, it's just don't give up hope is the main thing. Is that like I said in the post, the government can screw up your life within seconds of making a stupid decision. It's going to take you a long time to fix it, but you can fix a lot of these problems.
Yeah.
And that's what we do. We're problem solvers, and so don't give up hope would be the big takeaway, I would say.
Okay. Thank you so much. Thank you so much for the lovely message, John. Now, I would like to come to my next question, actually. So, about the H1B case that we were discussing, before we took the comments. So, if you can please talk about who are the plaintiffs involved in this case and how did you decide to represent them? And are there other attorneys also involved in this case?
Yeah. So, you're talking about the Narambalata case in Seattle for multiple
Yeah, yeah.
registration?
Mhm.
Yeah. So I'm doing that case with Jesse Bless. Jesse also worked at the Justice Department. We're there at the same time, and then he got out, was in private practice, and became the litigation director for AILA for a while. And then we've been collaborating on cases now for 2.5, 3 years, and so we looked at the issue together, and we thought we had what was the better argument in the winning hand, and just went to work on it. The plaintiffs are all just recently selected H1Bs that had their cap numbers revoked, and they're all from all over the country, really. But the lead plaintiff was in Seattle.
Okay. All right. Thank you so much for giving the information about, the other attorney and also, John, can you hear me?
Again, you cut out for a second.
Okay. Am I back? Can you hear me
Yeah,
now? I'm
I
so
can hear
sorry
you now.
about the lag. We have a lot of things going on. I don't know why it's happening, but I'm really sorry about it. Glad to be back. So, so I was saying about, thank you so much for talking about Jesse and also about, the case. So now I would like to know from you that what specific legal grounds did you base your argument on this recent H1B case that you won?
So the Administrative Procedure Act, like we were mentioning before, is the rule book that the government has to follow. And when they make a rule that they intend to use to punish people or sanction people, there's a very particular process they have to go through, because you've got to put the public on notice of what they want to do, what their proposed rule is. And then they have to let the public have enough time to analyze it and provide thoughtful comments.
Mhm.
After they receive the comments, they go back and they excuse me, they go back and analyze them and decide if they should change the rule in accordance with some of the comments, but they have to respond to the comments as well. And so they went through that rulemaking process when they created the new system in the lottery. They went through that rulemaking process when they tried to change the way the lottery was structured to give better chances to people with higher wages.
Mhm.
Then, that one obviously got kicked out of by the court, and so is no longer in effect. What was interesting though is in both of those cases, they were very clear that they had to go through rulemaking, and if there were additional changes that had to be made, the agency said, we will go through rulemaking. But they didn't. And so what they did is when they realized that they had kind of screwed up,
Mhm.
they made a quick fix. They cut some corners, and they made this rule that they knew full well that they would be using to punish people and sanction people. And they didn't do it the right way. They didn't give public notice.
Mhm.
So if you think about it, the only people that really saw this was the admin staff that were filing all the registrations. If collusion would occur, presumably it's going to be at the executive level. And so the admin staff filling out the forms isn't going to know. And so they're not on notice of what happened. And the executive staff who, made the decisions never knew ahead of time because the agency never published it in the Federal Register. So I think that violation of the notice and comment rulemaking is going to probably what gets us there.
Okay. But this must have taken a lot of strategy and a lot of planning from your and your team's end, right? From your and Jesse's end, especially. And so, how did you and your team actually prepare for this battle? If you can also walk us through that. And were there any key legal concepts or strategies you relied on, or were there any precedents from past cases that influenced your strategy?
Yeah, so one of the interesting things is the Supreme Court 2 years ago came out with a ruling that said merely posting something on a government website is not an adequate substitute for notice and comment rulemaking. So that case for us is very helpful, put it that way. But in terms of the meat of the argument, a lot of research. I couldn't tell you how many hours I spent looking through old versions of the regulation, looking at the comments that were made during the rulemaking process for multiple different rules that impacted the lottery, and just looking for those small nuggets that will help the case. And we put in the time, we put in the work, and I think we have a good case on this issue.
Okay. And now that we are speaking about the preparation, so was it like putting together one-page complaint, or was it more like sorting out through those thousand pages of legal document? What exactly goes into preparing a case like this?
I wish it were a one-page complaint. My life would be so much easier if it was the case.
Right.
I think this one ended up being 40 some odd pages.
Okay.
So what you have to do is you have to look at the facts for each individual plaintiff, collect all their documentation, go through it, make sure that everything lines up, and then you have to go through and you write your arguments. You put the facts of what happened, you put the details about the plaintiffs, then the background for the law, and then why the government violated the law. And it is a lot of work. I'll be honest,
I'm sure.
it's a lot. And so, it's something that when done right, it takes a lot of effort.
Wow. And how much time did it take for you to prepare those 40 pages document?
Well, so if you include the research going into it,
Yeah.
probably 3 or 4 weeks.
Okay. Wow.
Yeah.
That's a lot. Okay. And now that we are speaking about the timeline, can you also talk to us about how much time did this case actually take from filing the complaint and everything, and then actually winning it?
So that there is one thing in the timeline of litigation that we can guarantee or predict with some certainty.
Mm-hmm.
And that is, once you file the complaint, the government has 60 days to review it and decide what they're going to do.
Mm-hmm.
A lot of times in that 60-day window, they will change their decision, issue a new approval notice, and go on their way. That has happened in one of the multiple registration cases so far. So if it doesn't resolve by the 60th day and they don't settle the case, then they do one of two things: file a motion to dismiss or an answer. In the Naram Balata case, I filed a motion to dismiss, saying that the court didn't have the authority to hear the case, basically. And so we responded to their motion to dismiss, and then they filed a reply brief, and it was with the judge for probably 2 to 3 months. So from the start of filing the complaint to a decision on the motion to dismiss was probably around 6 or so months, I think, as I recall. So that timeline is long. Now we move on to, they have to file an answer, and they have to produce the administrative record in all of the plaintiff's cases. And so we will brief summary judgment using those administrative records. And summary judgment is how the court's going to make its final decision.
Okay. All right. Okay. And John, also, if you can talk to us about what actually motivated you to challenge the government's action, in this specific case.
It really kind of offends my conscience that they would punish people for the actions of another person. And we see that happen over and over again. They blindside the employees and make the employees pay for the actions of somebody else. I noticed that when I was working in the government, when it comes to H1Bs, the entire enforcement mechanism is geared towards hurting the employee, and they really don't have any plan or coherent strategy for dealing with employers. And so, it just, to me, it just seemed unethical and wrong that they would be doing this. And, anytime you get annoyed or pissed off, you tend to work harder. And so that kind of helped dig into the case.
Okay. But then, John, also I would like to know from you, you have been on the government side for, defending them for the longest time also, right? So, but then now you have taken the plaintiff side. So what actually made you decide this shift?
So frustration, really. Just
Okay.
frustration dealing within the agency. Looking at the law, saying we're wrong, if we get sued on this, we're going to lose. And the agency really not caring. They were more concerned about the efficiency of their processes than they were about getting it right. And this whole issue of notice to beneficiaries who are about to be punished highlights that issue. It would be too much work for them to actually follow the law and give notice. So they do shortcuts, and they think that they can get away with it by not giving the person notice that deserves it, and save some money and time by doing it that way. And hopefully that will change as a result of these suits.
Okay. But then, John, also I would like to know from you, it's no secret that taking on the government in a legal battle can be, intimidating for many people, right? And so there's often a fear that, they might get into trouble or face repercussions, right, for challenging the authorities. So if you can also talk to us about this common concern that people normally have, and what advice do you have for those individuals who may be hesitant to take the legal action against the government?
So the first thing to keep in mind is anytime you're suing the federal government, the rules are stacked in their favor. So you start off right off the bat with the government having a head start or a lead in the case. And so you really have to outwork and outthink them in order to win.
Mm-hmm.
So I would say probably the government wins more than 60 or 70% of cases that they litigate fully. So just understand that it's not a guarantee, it's not a lock, it's something that's going to require a lot of work to get done. But in terms of the actual employees, I think the best way to answer that is with an experience from when I was in the government. I would look at potential litigation cases at USCIS and the AAO, and there would be nothing in the file that would suggest that the petitioner was going to sue or do anything in court. It's just
Mm-hmm.
what's
Yeah.
that?
No. Please go ahead.
Oh, so with the AAO, I'd get these potential litigation cases, and there would be nothing in the file that would suggest it was a potential litigation case. It was just a regular appeal.
Mm-hmm.
And what made it a potential litigation case is the company had sued before. At that point in time, there was like 12 lawsuits a year on H1Bs.
Mm-hmm.
And so it was very rare. And somebody had sued before. It was everybody's memory of that happening. And so a potential litigation case was code for don't deny this if at all possible, because we don't want to have to do the extra work that litigation causes. And so I know a lot of people think that the government will retaliate against them or like seek them out and punish them. For the most part, I don't see that. For the most part, I see if you're annoying to the government, they try to leave you alone because they don't want to deal with the extra work.
Okay, but John, I also would like to know that is it even legal to sue the government? Because it sounds like a plot straight out of a legal drama.
It's not illegal to sue the government, but it's illegal for the government to retaliate. And so if they do retaliate, there's things called Bivens actions, which allow you to sue whoever was responsible for that decision.
Mm-hmm.
If you can prove that it was done illegally. And that's one of the few areas where you can actually get money damages as a result. But typically, it's very difficult to find that type of evidence that they targeted somebody. I think empirically, just looking at it, I don't really see it happening. I see most of the time when the government loses an issue, they change their decision, they issue a new approval, and that's the last we hear of it. And so I'm not terribly concerned about retaliation for people that sue the government. If you think about it, I know cultural differences exist.
Yeah.
Our American culture is far more confrontational, and we are far more disrespectful of authority, and our law kind of reflects that. The Administrative Procedure Act basically just invites the public to sue the government if they don't like what's happening. And so lawsuits for government employees, it's not a personal issue for them. Mm-hmm. It's just the cost of doing business. It's the way the system was set up. And it's something they kind of expect.
Okay. And, now that you have mentioned cost, so I would like to talk to you about cost as well, because many viewers, I'm constantly getting these messages from people on LinkedIn, YouTube, and also on my WhatsApp as well. So people are really wanting to hear some suggestions and answers from you. But before we move into viewers, I would like to actually, take all of my questions. So, yes, I was talking about cost because you mentioned that. So, many viewers here might be wondering the financial implications of taking legal action against the government, right? So if you can please break it down for us.
So the downside is that when you sue the government on these cases, you can't sue for damages. You can't sue for money to recoup the loss that you suffered because of their stupidity. So that's unfortunate, because a lot of people have to wait months and months and months without a visa, without work, before they get restitution. But they never get full restitution. They just get their visa back. Mm-hmm. And they pocket for living expenses for months. The only way you can get money back out of the government is if they fight the case tooth and nail all the way to the end and lose. And then the judge has to find that they were unreasonable in their defense of the case. If that happens, then you can get your attorney fees back. Probably, depending on how much is spent and how much the court awards, you may or may not cover all of your costs. So that's the expense. On the plaintiff side, it really depends on the type of case. If it's a case that we've seen and done before, that helps. It gives a little bit of a head start, and it makes things a little more cheap. But on a case that comes up that's an oddball issue that we've never worked on before, those are going to be a little bit more expensive.
Okay.
Yeah, there's also a difference between group cases and individual cases. Those oddball issues tend to be individual cases. And then the group cases are things where we're taking on a practice, procedure, or policy of the government that's impacting a whole bunch of people. In a group case, we can put them together and get economies of scale and then bring the costs down. For the individual cases, there's really no economy of scale because we're probably going to work that issue and never see it again. And so that's why those ones are more expensive.
Okay. All right. Got it. So, you also said that the government chances of winning is 60 to 70%. And, but then people, if you connect with John directly, so maybe the chances of government winning goes down and your chances of winning, gets high. So if you directly want to reach out to John, so what you can do is you can give him a call at his number, which is +1 703 2168 8148. His email is john@wasden.law, and his website is wasden.law. And yes, you can reach out to him through these details. And John, also, I don't know if you got a chance or not, but there were a couple of articles also written about this. So I saw Times of India writing an article about this, and also Economic Times. So if I would like to ask my team to, if you can please show those two articles here on the screen so that people can also have a look at those articles. Yes, here they are. One is from Economic Times, and there were so many actually, but I chose these two articles, Economic Times and Times of India actually. So they covered this whole case and they talked about it. So John, Lubna Kalbi was the journalist who wrote, I think, on Economic Times. So I'm sure you must be really busy, and I don't know if you got time to go through these articles or not. But do you have any message for them?
Yeah, so I've dealt with Lubna on several cases where we've talked about our court wins and court developments, and I read her stuff all the time. She does really great reporting.
Great. Thank you so much. And also, John, but there are many viewers who also must be wondering that how exactly is this case going to benefit the H1B community and our viewers? So can you give some insight into the broader implications of your this recent victory?
Yeah. So assuming it catches on nationwide, we will probably have to fight the same issue in multiple different courts across the country in order for it to be a fixed and binding situation. But what it means is that they can't go after your cap number. These teams that are around looking for reasons to revoke a cap number a few months before your visa is current, that's not going to happen because they have to give you notice and an opportunity to respond if we're ultimately successful in this issue across the country. And you won't get blindsided by that. And that'll be a big benefit. It'll be a lot of extra security for everybody that's in the situation. And so, yeah, the frustrating thing is for those folks, that get blindsided with a cap number revocation. Even if they were to have found out about it ahead of time, the government wouldn't allow them to respond. They won't accept anything from the beneficiary. Mm-hmm. And then, a lot of these things are 12, 13, 14 years old. And, good luck getting information or evidence who keeps things that long to show that, the government's wrong. So it's a very stressful situation for folks. I think the fact that the government has to give them notice, or will start to have to give them notice, means the government will be doing less of this because of the workload.
Okay. But does this also have any relevance to the companies? In the interim, there was another problem, John, where companies have put start dates beyond October 1st. So for the viewers, let me tell you, when the H1B is picked, they have to file. When the H1B is picked and they have to file, it starts from October 1st. Even we have done, one starting January 1st of the next year, and they have denied the application actually. And later they came up with a new rule stating that no, it was incorrect, and whatever. So for those who may be facing similar challenges or need legal assistance, how can they reach out to you, and how can you help these people, and also what kind of support can you offer to individuals in similar situations? And okay, maybe I can take this second part of my question after you answer this first part.
Sure. So anybody that's in the situation where they're facing an adverse consequence because of government action or procedure can challenge it in court. So then the screw ups in the mailroom that you're referencing, the denying cases because of the date incorrectly, and also another thing that we see kind of commonly is USCIS revoking things, saying that they sent out a notice of intent to revoke that was never responded to, but the employer never got it, the attorney never got it, nobody ever received any type of notice. Mm-hmm. And so a lot of times also the flip of that is they get the notice, they send in the response, and the government loses it and says, you never responded. Those cases are very easy to win. We file suit on that, and they usually resolve very quickly, especially when the employer or the attorney has, shipping confirmation that it was sent. And so that's a common scenario, unfortunately.
Okay, but then what are the services for the companies? And then,
So for companies, we do site visit defense. We train their employees on how to deal with FD&S. It's no shock to anybody on H1B that FD&S has become more and more aggressive, and one might say rude as time goes by, and their numbers have been increasing. So, in 2018, they had 800 employees at FD&S, and now I think they're getting close to 3,000. And so, we train the employees to handle site visits that are almost certainly going to happen. But the employers, when they have an issue that affects them all, they will go to court, usually under the ITServe organization, because ITServe can sue the government on regulations and clear, explicit policies that are out there on the behalf of their companies. And that's usually the most efficient or streamlined way to do it.
Okay. All right. Thank you so much for that, John. Now, before we, move into our second case, which is about Sridhar Aluwala, I would like to take a few comments from the people because I'm getting a lot of comments, actually. People are really looking for your guidance here. So let's just take Oluyinka. I hope I'm taking the name right. And he has posted on LinkedIn. And Oluyinka says, what guidance can you offer to Nigerians in the field of software engineering who aspire to relocate to the United States, particularly those who have faced multiple visa denials at the embassy? What do you have to say?
You got to find a petitioning employer that wants to hire you and have them put in for the lottery for the H1B. I mean, that's really your only option. Once you get an H1B, you should be fine, because one of the big problems that they have from people coming from Africa on other visa categories is the intent. You have to have a non-immigrant intent when you get that visa, meaning it's a temporary situation and you're going to come back to your home country. Far too many people can't show that they have a non-immigrant intent and that they don't actually want to permanently immigrate. The H1B doesn't have that requirement. It's a dual status visa, and so a dual purpose visa. So the H1B would be your really only option, I think, or your best option for getting into the U.S. IT market.
Okay, so Olenka, I hope you've got the answer for your question. If you have any more questions, please let us know. Please post them. And thank you so much for joining this live session. So, John, now let's take another viewer question. This is from a viewer called Empire, and Empire wants to know. Let me get the rules straight. So they can revoke the employer's petition for fraud, but can't revoke the cap number that was gained from the fraud once the employee is not involved.
So yeah, that's our argument, is they can't revoke the employee's cap number unless the employee is the one that committed fraud. And the government has to establish through evidence that it was the employee that actually committed the fraud.
Okay, and he also has a follow-up. So he is asking, I think, 2 or 3 questions. Let's take all of them. So second, he wants to know, unfair to lose your cap number because of someone else's bad action. It's also unfair that those employees benefited from this at the expense of an employee and employer that has done it correctly. I think there is a second part to it. And he says the government needs a better system because someone else lost the opportunity because of that employer's fraud. What do you have to
say? They did come back and they changed the way they did this year's lottery. And so what's funny is the way they restructured the lottery for this year is almost identical to the way that it was suggested in the comment process back in the 2019 rule. And so the government could have avoided this whole thing if they hadn't been in such a rush to push out a new regulation changing the lottery. But because they were in a rush, they didn't really want to do any work at the last minute to change their rule and their regulation. So the new regulation that came out went through the rulemaking process, prohibited, well, it didn't really prohibit multiple filings, but it took away any incentive for multiple filings. So now if you have 20 different people, 20 different companies registering for you, you're still only going to be in the lottery that one time. And so that has really kind of made things more fair, and it hasn't it's killed the situation that was in the news so much the last few years with the lottery.
Okay, all right. So, John, I'm constantly looking on my WhatsApp as well because, I'm getting a lot of messages from our viewers on WhatsApp too. But before I move into the WhatsApp viewers, I would like to take this next viewer question, SPK24. And he says, how will that work? They may start giving the employees notice, which they can't respond. What do you have to say?
So, it would just depend on the notice and what they're alleging. If they're alleging that the employee did something wrong, that's something that's easily addressed. If they're alleging that the employer did something wrong, well, that's on the employer. They can lose their right to hire and employ you, but you still keep your cap number. And that's what we're shooting for.
Okay, all right. So SPK24, I hope you have got the answer. Thank you so much for your question. And also, please let us know where you're watching this live session from. And thank you again. And don't forget to subscribe to the channel. And let's take next question. And this is from Anushka. And she says, what proactive measures can individuals and employers take to minimize the likelihood of encountering legal hurdles in the H1B visa application process?
So the first thing I would say is be very, very careful anytime you're dealing with FDNS.
Mm-hmm.
And honestly, I would say you shouldn't talk to FDNS unless you're doing it through your attorney or your attorney's present. We've heard all kinds of horror stories about, FDNS people coming in, yelling and screaming and threatening, making threats they really can't make good on, but telling people you have to, give me a statement saying you did this or you're going to get your visa revoked. And so people get scared. People sign away their life basically in that situation, and they get taken advantage of. But the FDNS officer gets to write a great report and look like he's a hero. So if your attorney's there, that whole scenario is avoided. If your attorney's on the phone or they're present, the FDNS officer can't be an aggressive ape, basically. And so they have to control themselves, and that helps you. The other thing is, don't respond to their emails. Have your attorney respond to the emails. Anything that you say to the government could conceivably be used against you in a fraud finding. Anything your attorney says on your behalf
Mm-hmm.
attributed to you. And so you want to definitely avoid any type of fraud finding against you, and you want to avoid any communication that would lead to a revocation of your visa.
Okay, all right. So Anushka, I hope you have got the answer for your question as well. Yeah. So Anushka, thank you so much for your question. I hope you have got the answer for your question as well. So thank you so much, all the viewers, for your lovely question. I know I still have a lot more questions that I need to take. But before I move into that, John, let's quickly shift our focus to the case of Sridhar Aliwala, and which is truly a tale of injustice and confusion, right? Because firstly, John, okay, before I talk about anything else, I would like to know what exactly is Sridhar is being accused of, and from what we understand, he seems to be caught up in a mess that he had no part in creating.
Yeah, and the government's even admitted that. The government in court has admitted he didn't do anything wrong. And so it begs the question, why are we still here? Why are we still fighting?
Right.
I think that's another case where I'm optimistic of our chances for success. We've briefed some judgment. Now we're just waiting on a court to make a decision.
Mm.
What happened in that case is they revoked his initial H1B without giving him notice. And 12, 13 years down the road, they try and kick him out of the country because he doesn't have a visa. Thankfully, his spouse is an H1, so he's able to switch to H4. But that's kind of their game plan, is they want to eliminate as many H1Bs as they can. In his particular case, what they were alleging was that the work location on the LCA, that initial LCA, didn't match with where he actually worked. So you can have multiple LCA or multiple locations on one LCA and work at any of those locations, and then the employee has to be paid based on that location.
Mm-hmm.
What they didn't provide us in the evidence was that initial LCA that could have corroborated that he was actually working in the right location. So all the way back when he was on OPT, he had a project.
Mm-hmm.
He, is working for, it was a major bank in the US, and then he gets selected for the lottery and then keeps that project with his new employer. So it's entirely likely, and I would say more likely than not, that when they filed the petition, they listed both the company headquarters and the client location on the LCA. And the government never provided the evidence that they didn't. And so that, I think, is going to be an area where they're going to have some problems.
Okay. All right. I mean, if the government they themselves accepted it, so we can only be hopeful that
Yeah,
you're also going to win this one. But John, also I would like to know that it's puzzling to hear that they are digging up records from as far back as 2010, when Sridhar wasn't even involved in any wrongdoing. And can you please explain why they are going so far back, especially when there are no legal requirements to keep records beyond 7 years?
yeah. It's something that started under the Trump administration.
Okay.
So, yeah, the Trump administration really kind of kicked off the explosion of FDNS,
Mhm.
and they needed work for these guys to do. What they actually did is they went back and they rehired a whole bunch of old employees that had retired as contractors to go through all of these cases and look for any reason they could to eliminate people's cap numbers. The the weird thing about administrative agencies is the president comes in, he gives a little bit of direction, but what the president does, the policies he creates, tend to outlive their presidency. And so Trump came in, he really weaponized USCIS. He tried to make it more into an immigration Gestapo. And that mentality within the agency has not shifted back, even though there's a new president.
Mhm.
And I don't imagine it will shift back anytime soon.
Mm. Okay, okay. All right. But thank you for answering the question, John. But also, it's mind-boggling to think that Sridhar's entire life and career are being upended over something that happened over a decade ago, right? And
Yeah.
with this visa now at risk of revocation, how? I mean, what does the future hold for him? If you can please also talk about that.
So luckily, his spouse has an I-140 and will be able to apply for a green card relatively soon. So he can stay on H4. But
Yeah.
I've had other clients that have had to leave the country because they don't have any status to go into.
Mm.
So it's really unfair that you've got somebody working in a government office who has no understanding of what you're doing for your job.
Mhm.
You know, basically taking pot shots at you and your history on things they don't really fully understand, and they have a lot of ability to mess your life up very quickly.
Yeah. Yeah. But is he protected in this situation? And I mean, how is your team it- ensuring that his rights are upheld?
So I think we'll be successful in getting his initial H1 reinstated, or the government will be enjoined or stopped from saying that he doesn't have an initial H1.
Mhm.
So I think we'll win on that issue because the record just doesn't support their decision. And if he has his cap, no problem. As long as he has that cap number, he's fine.
Mm. Okay, okay, all right. Well, I'm glad to hear that. And but here's a burning question on many people's mind, John. So, while this legal battle is being fought, can Sridhar continue to work? And I mean, how are you planning to assist him in obtaining a work permit during this uncertain period?
So ordinarily for plaintiffs, if they don't have another status that they can change into that allows work authorization, once they lose their status, they can't work, which is obviously a huge strain on them because they've got to pay out of pocket while the case is being resolved. So if you can move into say like an H4 that has an EAD available, there will be a temporary disruption in your life while you're waiting for the agency to process the H4 and EAD, but you'll still be able to stay in the U.S. legally and work legally
Mhm.
while the case is being resolved in court.
Okay, understood. But John, also given Sridhar's cooperation with the government and his innocence in this matter, could he potentially fall under another visa category that provides him with some form of protection? Like, I mean, for example, like, does he qualify for the U visa considering his cooperation with the authorities?
Yeah, so there's the U and the T visa that conceivably he could qualify for.
Wow. Okay.
Yeah, the the T visa is an interesting one. It's for victims of labor trafficking. And what the government's alleging basically in his case
Mm-hmm.
would potentially qualify as labor trafficking. So it's possible, but my guess is, just knowing the agency, those types of petitions for H1B workers will face a lot more scrutiny than any other type of petition.
Mm-hmm. Okay. All right. And John, also, I saw your LinkedIn post about Sridhar's case, and there, when you mentioned the whole thing, at the end of your post, you wrote, it is going to be a long wait, and you extended on the word, you actually emphasized on the word long. So,
Mhm.
I would like to know from you, can you elaborate on what factors contribute to this prolonged wait, and how do you and your team plan to navigate through this extended period of uncertainty for Sridhar?
Yeah, so right now we're at the stage where all we can do is wait. So all of the work on the case has been done, and we're just waiting for the judge to either hold a hearing and ask us questions or make a decision. And one of the nice things about being a federal court judge is you have lifetime tenure and can't be fired. So they can move at their own pace. And
Okay.
so, you know, there's really no prediction on when the court will actually make its decision.
Well, hopefully soon. Let's hope for the best. And I mean, given that the court has already said that he's innocent and he has nothing to do with it, so maybe let's hope for a victory of yours soon on this
Yeah.
case as well. Okay, so lastly, John, about this specific case, can you share any insights into the broader implications of this case for other individuals, facing similar challenges with their visa, and how can individuals in need of legal assistance reach out to you for help in navigating through, such turbulent times?
Yeah. So the first thing I'd recommend that everybody do is
Mhm.
keep everything. Keep all of your records. Be very meticulous, because if you need them in a crunch,
Mhm.
unexpectedly you get a notice of intent to revoke, you'll have the information that will be helpful in responding to that. So just document, document, document. Should
Right.
have everything on you scan it all and have it on someplace on the cloud that you can access it for the rest of your life. In terms of working with us, my website has a scheduling app. If
Mhm.
you want to schedule a time to talk, you can do that.
Okay, and everyone, his website is wasden.law. So if you want to schedule, you can do that by clicking on his website, which is wasden.law. And if you want to give him a call or send him a text or even WhatsApp message, his number is +1 703 216 8148. And you can also write to him on his email, which is john@wasden.law. All right. So, John, also, there are a few questions I would like to take before I let you go. I know you must be really, really busy, but I just would like to take, one or two questions before I end this session. So, Ashwin Daljit is here and he has a question. Can you discuss any recent precedents or trends in H1B visa litigation that applicants should be aware of?
So the main thing that we're pushing right now is notice to the impacted person. That's coming up in a couple of different ways. One is the multiple registration cases. One is the revocation of the initial cap number years ago.
Mhm.
And then the other is the OPT scam companies, the scammed employees or students into paying them for training and then never doing anything to get them a job. So all of those cases share a common element, which is the government never gave them notice before punishing them, basically.
Mhm.
What we're fighting for is to give everybody a fair shake and a fair shot at resolving or answering the agency's questions before they get punished. And I think we're on our way there. The case in Seattle, I think, is huge because it says that the employees can sue. And if they can sue, really they're entitled to notice and an opportunity to respond at the administrative stage.
Okay, all right. Thank you so much for answering the question, John and Ashwin. I hope you have got the answer. And one more question I would like to take is of Rajesh. I actually had taken screenshots from Reddit and Quora so that I can ask you questions from, people commented actually a lot about these H1B frauds. So I just wanted to take that, but because I know, you're really busy. So maybe in another episode, maybe. But for now, this question, how Rajesh is saying, how can you effectively challenge the government's exercise of discretion in denying an H1B petition, particularly when the denial is based on a subjective determination that, can we have the second part, that the petitioner does not meet the specialty occupation requirement? And what legal arguments and evidence can you marshal to demonstrate that the government's decision was arbitrary and capricious?
Mm-hmm. Yeah, so when we're dealing with specialty occupation cases, that was an issue we fought years and years ago, and it's been successfully resolved. It used to be you would file your petition, and these USCIS employees who had no understanding of IT, software engineering, or any of that would make a decision as to whether or not your job qualified as a specialty occupation. Now, keep in mind, most of these people couldn't figure out how to map themselves to a printer. And that's how computer illiterate they were. But they were making these decisions that, you don't qualify. So they were really kind of twisting some language in the Department of Labor's resources that kind of define occupations within the United States. The arguments in court went pretty well for us, which were, the Department of Labor said this occupation requires a degree in this specialty and this knowledge. Mm-hmm. The job that they offered requires that same degree and that same knowledge. Therefore, it meets the criteria for specialty occupation. The court really almost mocked USCIS's analysis and rationale for their denial on those cases. And now it's become much more simple and much more streamlined on the specialty occupation analysis. I think USCIS is trying to muddy those waters again with a new regulation, the modernization of the H1B. I think they're trying to bring back a lot of those murky standards. So we'll probably be fighting the same fight all over again.
Okay. All right. So thank you so much, Rajesh, for your question. Don't forget to subscribe to us. But one last question, John. One last question. I don't want to, miss out on this opportunity because I know you're really busy. So one last question I would like to take from the viewer. So Nancy wanted to know something, and she said, in what ways can skilled immigration contribute to addressing labor shortages in specific industries or regions? What role do social networks and support systems play in successful integration?
So, I think the answer to a lot of the country's problems is increasing high-skilled immigration. I personally want to live in a country that has the smartest people in the world, and we're starting to slip on our lead for that. And we need to bring in people. The frustrating thing is Congress is not going to do anything to fix a well understood problem. Immigration is broken for high skilled people. Mm-hmm. It's just not working right. And USCIS, for its part, has zero desire to change anything that they're doing. And so, you can advocate for change, that's great. But until Congress actually gets their stuff together and comes forward and does comprehensive immigration reform, it's just going to be ugly.
Okay, well, If Thank you so much, Nancy, for your question, and thank you so much, John, for answering. And there are a lot more questions, but I know you're really busy again. I would like to say this again and again because, this show was supposed to be for an hour, but then we extended. So thank you so much.
Mhm.
Uh, yeah, thank you so much for that. And unfortunately, viewers, that's all the time we have for the questions today. But don't worry, we will try to bring John back for another episode, and where we can discuss more about these cases, because you also have, like I said in the beginning, you had a recent win where you posted a couple of hours back about that, right? So maybe we can discuss about that too. Thank you so much for your time, John, and everyone. If if your question didn't if we didn't take your question, and if you directly want to reach out to John, what you can do is you can connect with him on his number, which is 703-216-8148. His email is john@wasden.law, and his website is wasden.law. And if you're looking for a project placement or visa sponsorship, you can reach out to me on my email, which is rajni@higheritpeople.com. My number is +1 732 707 9151, and you can also visit our website, higheritpeople.com. Remember, we also sponsor H1B visas and green cards. And that's a wrap for today's show, folks. So we have covered a lot of ground exploring the triumphs and challenges within the legal world with John by our side, from Victoria's H1B visa case to the ongoing saga of Sridhar's fight for justice. And it's been an eye-opening journey. So before we sign off, I want to extend a heartfelt thank you to you, John, for sharing your insight and your expertise with us. Your dedication to upholding the justice is truly, truly inspiring.
Well, thank you. It's good to be with you again.
Thank you so much for saying that. And to our lovely viewers out there, thank you so much for tuning in. And remember, if you find yourself facing legal hurdles or seeking guidance, don't hesitate to reach out for help. You already have John's number and his contact details. So we'll be back with another episode and another live session at 12. So just don't forget to stay tuned, and don't forget to subscribe to Immigration and Jobs Talk Show. But for now, I'll have to take your leave. I'm Rajni Bharara signing out for now. Let's meet soon.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 732-707-9151 or mail us at rajni@higheritpeople.com or visit our website www.higheritpeople.com.